3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through international trafficking and tested what the records could actually prove without speculation. Today, we are examining the cover-up and mapping what the documents show about actors, timeline, decisions, and institutional response. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is a series of non-disclosure agreements obtained through civil discovery, showing how victims were paid and then legally silenced.
And we really need to start with the mechanics of these agreements. I think when people hear cover-up, they picture something out of a movie, a shredder, cash in a bag.
Right, something illegal and clandestine.
Exactly. But the documents we have from the pinpoint database specifically, records like EFTA 0000199249, they show something much more bureaucratic.
Or sanitized.
Yes. The cover-up wasn't necessarily lawless. In many ways, it was lawful. It was executed by, weaponizing contract law.
I'm looking at one right now. EFTA 02382854.pdf. It's titled Settlement Agreement, and it looks, for all the world, like a standard legal document. It has the headers, the clauses.
It's designed to look mundane. But when you drill down into the confidentiality sections, the language gets incredibly specific. It binds the person signing to total silence.
On any and all interaction. That's the phrase used.
Any and all. It's a legal catch-all. And then you see this other phrase noted in the records, telling the truth after a settlement often run to. The snippet we have is incomplete, but the legal analysis that comes with it implies massive financial penalties.
So it's not just an agreement to drop a lawsuit.
No. It's an instrument to monetize silence. The structure is actually quite simple. If you speak, you don't just forfeit the settlement you received.
You owe them damages.
You owe them damages. You actually have to pay for the privilege of telling the truth about what happened to you.
It's a complete inversion of the justice system. The perpetrator doesn't pay for the crime, the victim pays to disclose it.
Precisely. And that's the critical transition we see in these files. There's a very clear strategic shift away from criminal exposure and toward civil resolution.
Okay, let's unpack that. For our listeners, why is moving a case from the criminal system to the civil system so important for a cover-up?
Well, in a criminal case, the state is the plaintiff. It's the people versus Jeffrey Epstein. The state, in theory, has an interest in public safety, in the truth coming out. You can't just write a check to settle a felony.
Theoretically.
Right. But in a civil case, it's a dispute between two private parties, Jane Doe versus Jeffrey Epstein. And private parties can agree to almost anything. They can agree to dismiss the case, seal the records, keep everything confidential. By changing the venue, you change the rules. You can legally bury the facts.
And that's the architecture of silence the documents describe. It's not just about paying someone off. It's about moving the entire dispute into a forum where silence can be legally bought and enforced.
Yes. Which leads us to the intervener's motion in the Giuffre versus Maxwell case. This is where we see let's call it the maintenance phase of the cover-up.
This involves Sarah Ransom and the fight over her deposition's confidentiality designation.
Correct. The intervener here, representing Alan Dershowitz, is arguing that materials, specifically Ransom's deposition and certain emails, should remain sealed.
And the argument they use, looking at the filing, it's that the emails are inflammatory and defamatory. The document numbers are ransom 000000273 through 557.
And that's the shield they use. The defense's argument is that because the allegations are so awful, releasing them would cause irreparable reputational harm.
But from a forensic standpoint, it's the legal effort itself that's the evidence.
It is. The document proves a deliberate and very expensive legal strategy to keep these specific records locked away. They aren't arguing about whether the events happened. They're arguing about the classification of the documents that describe the events.
And you see this pattern over and over in the main case file, Epstein case documents. There are multiple Jane Doe lawsuits. Each one is a potential leak in the dam.
And each one is met with the same response. A settlement agreement and a sealing order. It creates a vacuum. And inside that vacuum, Epstein's operation could continue.
That's a crucial point. These NDAs didn't just protect him from past actions, they enabled future ones.
Of course. If a victim from 2004 is legally silenced in 2008, she has no way to warn a potential victim in 2009. The legal system, simply by enforcing the terms of a private contract, becomes an unwitting accessory.
So let's move to the fuel for this entire machine. The money. You can't buy this much silence on credit. This is our second block of evidence, the financial trail. I've got the file 0000 check Epstein assets.pdf pulled up, and also the Wexner Foundation report.
The Epstein Assets Files, it's dense. It's a ledger, just pages of transactions.
Oh.
It's the kind of document designed to be boring.
Which is why it's so important.
Exactly. But if you take the dates of the wire transfers from that ledger and you cross-reference them with the filing dates of the settlement agreements we were just discussing, a very clear pattern emerges.
You're talking about establishing a cash for silence timeline.
It's right there in the data. You see a sudden flurry of financial activity, large transfers, funds moving from various trusts, that lines up almost perfectly with the dates these civil cases are resolved. The silence was quite literally purchased on a schedule.
Now, the Wexner Foundation document, the one titled Wexner Foundation Report, it talks about an independent review and details misappropriated funds. It confirms Epstein had significant control over Wexner's finances.
He had power of attorney. He was a trustee. The report frames these transfers as misappropriation, which may be true. But for our purpose here, tracking the cover-up, the label, whether it was theft or compensation, matters less than the sheer volume of capital he had at his disposal. We're talking about millions upon millions of dollars.
But here's the critical question. Does the ledger prove that the money from, say, Wexner's accounts was the specific money used for these settlements? Can we trace a single dollar all the way through?
And that is the gap. The documents absolutely verify the flow of enormous capital into accounts Epstein controlled.
Yeah.
We see the liquidity events. But can we say forensically with these files that dollar A from this foundation was used to pay victim B?
We don't have documentation for that.
We don't. The attribution is blurred. So we have to be very precise. We can confirm the massive asset transfers. We can confirm the settlement payments. We infer the connection, but we can't draw a solid line on the bank statements we have here.
There's another document here simply titled Partial Payments. That title alone suggests the record is incomplete.
It is. And this is where it gets interesting. When you compare the Epstein assets ledger against the financial requirements laid out in the 2008 plea deal, there are contradictions.
How's
The plea deal, which is file 10 #Epstein plea deal, it specifies certain amounts for restitution to named victims. But the asset files show transfers that just dwarf those amounts.
So where did the extra money go?
That is the question. And we also have a file in the directory titled Les Wexner Mob Ties Shapiro Murder File. Now, we have to be very careful with a title like that. It's editorialized.
Right, it's a charge title.
But the relevant data point for this investigation is the financial tether. The documents show Epstein had access to a fountain of capital that doesn't seem to align with standard income from misstated profession. And that capital is what paid for the legal firewall.
It funded the NDAs.
It funded the entire architecture of silence. Without that constant cash flow, the system collapses. The cover-up had a very high burn rate.
This brings us to the institutional side. Money can silence victims. But what about law enforcement? What happens when the police won't back down? I'm pulling up what's been called the smoking gun letter. It's dated May 1st, 2006.
This document, this is probably the single most damning piece of paper in the entire archive when it comes to the state-level cover-up. It's a formal record of obstruction.
It's a letter from the police chief of Palm Beach, Michael S. Ryder, written to the state attorney, Barry E. Krischer.
Just read the opening. The tone is extraordinary.
I continue to find your office's treatment of these cases highly unusual.
Highly unusual.
In the world of formal correspondence between a police chief and a district attorney, that is a 5-alarm fire. You do not put that in writing unless the system is completely broken down. Ryder is creating a record.
He's documenting his objections for the file.
He is. He goes on to say that Krischer's office told him they did not believe the victims were credible. And then he details a suggestion from Krischer's office that, it's astonishing. They wanted to issue a notice for Epstein to appear on misdemeanor charges.
A notice to appear. Like a traffic ticket. For crimes the police had built a felony case for. Sexual battery. Crimes against minors. The police had probable cause. They had evidence. The decision to downgrade that to a misdemeanor. That wasn't an investigative failure. That was a prosecutorial decision.
This is the documented institutional decision to kill the case.
It is. Ryder is practically begging Krischer to step aside. He writes, and I'm quoting, "Consider if good and sufficient reason exists to require your disqualification." The police chief is telling the state's top prosecutor to recuse himself. He knew the case was being blocked.
And this letter gives us a date, an anchor for the timeline, May 1st, 2006. This is the moment the official system turned on the victims.
The letter also details how Krischer's office justified this, saying the victims were promiscuous.
Minors.
Minor victims. They were victims shaming to justify inaction. It's a defense tactic being used by the prosecution. And that's the perversion of the system that Ryder is documenting. He saw the prosecutor's office acting like Epstein's defense team.
So while the prosecutor is stonewalling the police, what's happening to the witnesses? I'm looking at the Sarah Ransom emails again. File ransom 11000284.
This is the other side of the coin. This is the enforcement that happens outside the courtroom. Ransom writes that a friend of hers was coerced into silence.
She claims there were agents of intimidation involved.
She does. And we have to be very disciplined here. Ransom's credibility is attacked repeatedly in other filings, particularly by Dershowitz's legal team. They claim she's a fabulist. But that doesn't change one key fact.
The email is real. The claim exists in the court record.
Exactly. The existence of the coercion claim is a documented fact.
But the identity of the people doing the coercing, the agents of intimidation.
That is unverified in these public files. We see the claim of intimidation. We see the effect of witnesses going quiet. But we do not have a police report or a name.
So we don't have documentation for that.
We do not. But if you put yourself in a victim's shoes, the state attorney is on record saying you're not credible, and you're receiving threats. Silence becomes the only logical path to survival.
Which leads to how this narrative was managed in public. Block 4, media suppression and narrative control. Because Epstein wasn't just hiding, he was actively curating his image. The Jeffrey Epstein emails released by the Oversight Committee are key here.
They're critical because they show his activity long after his 2008 conviction. The common belief was that he was a social pariah cast out. These documents show that's not true.
Here is an email exchange from 2015 between Epstein and the author Michael Wolff. Epstein is discussing what he calls valuable PR and political currency in relation to Donald Trump.
Look at that date, 2015. 7 years after his conviction. He's still trading in influence. He's still leveraging his connections. The term PR currency suggests he saw his knowledge of powerful people as a kind of asset, something to be managed and spent.
And another one from 2011. Epstein writes that Trump spent hours at my house and calls him the dog that hasn't barked.
That's a Sherlock Holmes reference. The dog that didn't bark in the nighttime. It refers to a significant non-event. It implies Epstein was tracking who was speaking out, and more importantly, who was staying silent.
So he's not just a subject of the media, he's an active player trying to shape the narrative.
He's a source. He's feeding information, managing relationships. He's playing a very complex game with the press at a time when most people assumed he was irrelevant.
Now, we also have a source folder in the archive titled The Lying Media. It has some very strange documents in it.
Right, and we need to address this directly. As forensic auditors, we have to separate signal from noise. These specific documents, some are anti-Semitic texts, others are broad conspiracy theories. They don't provide any concrete, verifiable evidence about the Epstein cover-up.
They're noise.
They're disinformation. They're a distraction from the actual documented method of media suppression, which wasn't some grand media conspiracy. It was bureaucratic. It was done through the courts.
What do you mean?
Look at the court docket. File after file, titled Notice of Filing Transcript from the USA versus Epstein case. July 2019, August 2019.
I see them.
These are often filed under seal or with redactions. The real media suppression wasn't a conspiracy by the media. It was the court system sealing the primary source documents from the media. The courts were the ones drawing the curtains.
Which brings us to the ultimate legal shield. Evidence Block 5, the non-prosecution agreement, the NTA.
This is it. This is the document that takes the state-level obstruction we saw in the Ryder letter and elevates it to the federal level. It's the capstone of the cover-up.
I have the file. 10 hashtag Epstein plea deal. Epstein plea deal 2008.pdf.
Go to the immunity clause. Read who it covers.
Right.
It's not just Jeffrey Epstein.
It grants immunity to any potential co-conspirators.
Any potential co-conspirators.
That is incredibly broad.
It's unprecedented. A standard plea deal. You immunize a defendant so they'll give you testimony against their co-conspirators. You flip the little fish to get the big ones. This agreement did the exact opposite. It used the defendant to build a legal shield around everyone else involved.
It didn't just end the case against Epstein, it ended the entire investigation.
It shut it down completely. Recruiters, financiers, other participants, all of them were given a get-out-of-jail-free card.
And the victims were never informed this was happening.
Correct. Which, as the House Oversight Epstein Files detail, was a clear violation of the Crime Victims' Rights Act, the CVRA.
So, to be clear, The federal government, specifically the U.S. Attorney's Office for the Southern District of Florida, formally and legally agreed to stop investigating.
They killed the grand jury investigation that was already underway. They sealed the evidence. They immunized the accomplices. The MPA is the smoking gun of the federal cover-up, just as the Ryder letter is for the state. A two-stage kill switch.
And the U.S. attorney at the time was Alexander Acosta.
His office signed off on it. Years later, the justification we heard was that they were warned Epstein belonged to intelligence and to back off. But the document itself, the legal instrument, makes no mention of intelligence. It's a contract that legalized the cover-up.
This is the natural transition, then, to our last block of evidence, the most difficult one, the intelligence claims.
Yes. And here we must be more disciplined than anywhere else. There are a lot of loud claims and very few quiet documents.
Okay, so let's apply the test. The central claim is that Epstein was working for an intelligence agency. Mossad, Unit 8200, CIA. The list varies.
All right. The first question is always the same. Do we have a government document, a payroll record, a handler's report, anything official in this archive that lists Jeffrey Epstein as an asset?
I'm searching the files. No, we don't have documentation for that.
We don't. We have analysis. We have books, like the excerpts from Whitney Webb, that build a very compelling narrative based on associations. Robert Maxwell, Promise Software, historical context. It's a strong circumstantial case. But in this specific file dump, there is no primary source document from an agency claiming him.
What about the blackmail tapes? The Press for Truth source mentions tapes being confiscated by the FBI from his safe.
The source mentions it, but does the FBI's own inventory, their own report, list those tapes? Do we have a chain of custody log in the files released by the DOJ?
Looking at the FBI merged file, no. There is no inventory of blackmail tapes in this release. The existence of a safe is documented. The contents are not.
So we have to classify that as unproven from this data set. We also have files from sources like Kash Patel and SuperZar Pro.
How do we categorize those?
As interpretation and analysis. They are arguing a theory. They're connecting dots. But they are not primary records. They are closer to op-eds than to evidence. We cannot give them the same forensic weight as the MPA or the Ryder letter.
But there are verified facts that fuel this speculation. The flight logs. File 7 tagged Epstein flight logs.
Absolutely. The logs are verified. They show the transport of extremely high-profile people.
Yeah.
Bill Clinton, Donald Trump, Prince Andrew. The flights happened. The names are on the manifests.
The claim, though, is that these were intelligence honey traps.
And that's the leap. The documents show the transport. The flight log is a transport record. The purpose of that transport remains undocumented in these files. We can infer what happened to the destinations based on victim testimony, but the log itself doesn't state a purpose.
And finally, the Ghislaine Maxwell connection. We have her unsealed deposition.
Yes, which is a masterclass in evasion. She denies and obfuscates for hundreds of pages.
And the claim from other sources is that her father, Robert Maxwell, provides the link to intelligence services.
Robert Maxwell's connections to various intelligence agencies are a matter of historical record. That's a fact. The question is there a document in this archive that shows Ghislaine Maxwell was operating under a similar mandate in the 2000s?
And is that...
There is no direct document here linking her actions to a specific intelligence agency's directive. We see her as an accomplice, a manager, a facilitator for Epstein. We do not see a report from her to a handler.
So let's put it all together. Let's synthesize the timeline of what the documents actually prove.
It begins on paper in 2006, May 1st. Police Chief Michael Ryder documents obstruction by State Attorney Barry Krischer. The local system is compromised.
Then 2008. The federal non-prosecution agreement legally seals the entire case and, crucially, grants blanket immunity to all co-conspirators. The federal system shuts the door.
And from 2008 until his rearrest in 2019, you have the maintenance phase, the architecture of silence, NDAs, civil settlements, and Epstein actively managing his political currency as seen in the Wolf emails.
And then 2019, his arrest is followed by a flurry of court filings trying to seal transcripts and keep information from the public.
So the cover-up isn't a theory. The documents show it was a multi-stage administrative process involving the state attorney's office, the Department of Justice, and the mechanisms of civil contract law.
And the intelligence angle, to be clear.
It remains a high probability inference. The sheer level of protection he received was, to use Ryder's word, highly unusual. But a specific smoking gun document proving he was on an agency payroll is not in this archives. We have the shadow, but not the fingerprint on the page.
So we have proven the mechanism of the cover-up. It was a combination of prosecutorial refusal at the state level, federal immunity via the NPA, and financial silencing through NDAs.
Correct. But we remain without documentation for a specific blackmail library or official intelligence service records. The files tell us how they covered it up. They only give us clues as to why.
Next time, the scientists.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.